Hi everyone, in this week's video we are discussing whether or not an employer can withhold company sick pay in the event that an employee takes sick leave following receipt of an invitation to a disciplinary hearing or performance or absence meeting. Now the position is only relevant if there is enhanced sick pay in place, so it's very difficult to withhold statutory sick pay once someone reports their absence if they've certified that correctly either by a self-cert or a medical certificate. But many businesses do operate an enhanced company sick pay scheme. So there are different positions to consider, and that generally depends on the wording of the contract and or the scheme itself. The first position we'll consider is if the scheme is entirely discretionary in nature. So if the contract or the policy says that a certain amount of company sick pay is payable at the absolute discretion of the employer. Now, on the one hand, that gives a lot of flexibility and freedom to the employer to decide whether or not to pay and how much to pay. However, all exercises of discretion are subject to a duty to act reasonably, rationally and fairly. So the risk is if an employer decides not to pay company sick pay, the employee may see that as a breach of trust and confidence if that decision can't be justified. I think it would be quite extreme to argue that and to resign and pursue a constructive dismissal complaint. But if the practice of the employer has always been to pay company sick pay and suddenly it exercises discretion not to because an invite to a disciplinary hearing is being given, that could go in the employee's favour in that argument. The employer might also try to argue that the decision not to pay sick pay is a punishment for the disciplinary offence, particularly given it hasn't been ruled on yet. Has the decision to give a warning or dismiss already been prejudged by virtue of the penalising of the employee by way of sick pay? The second position is if the wording of the contract is absolute. So if the employee has an entitlement to a certain amount of company sick pay in any rolling 12-month period, for example, and there is nothing else stated in the contract or policy. Now, in those circumstances, it's extremely difficult to make a decision not to pay company sick pay because an invite to a disciplinary has been sent. That's because the policy is absolute. So the employer doesn't have the flexibility to make a decision not to pay because there is nothing in that document which gives them the right to do so. The employer would have a much stronger argument in that case if pay was withheld that there'd been a fundamental breach of contract. The final position, and this is fairly common for a number of employers, is that they have a policy or contractual terms in place which says the employee is potentially entitled to a certain amount of company sick pay over a period of time, but that there are rules and exceptions, exclusions that do apply to that entitlement. So, for example, if the injury is self-inflicted, such as a sporting injury, if the employee is in receipt of a warning already, or if they don't have particular service, sick pay will be withheld. Some employers do build in that if an employee goes off sick once they've been invited to a disciplinary hearing, sick pay will be withheld in those circumstances. So contractually, it would be much lower risk to withhold sick pay in those circumstances. The difficulty is, again, that an employee could try to use that to their advantage in suggesting that the disciplinary outcome had already been predetermined because they'd been punished by the removal of that pay. And the final consideration in all of these cases is disability discrimination. So if, for example, an employee has a long-term stress-related condition and the sending of that disciplinary invitation letter genuinely causes that stress-related condition to flare up to the extent that an employee cannot come to work, the decision to restrict sick pay in those circumstances could, allegedly, according to the employee, amount to less favourable treatment or discrimination arising from disability. So just be careful of taking a blanket approach in all cases there. Complex area. If you do need any further support on this question or anything employment-wise generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.